Criminal accountability to restore international peace and security. Promoting and building the rule of law at the international level. Although international criminal justice has historically been interwoven with armed conflicts, it is only with the establishment of the United Nations International Criminal Tribunals in the 1990s in Yugoslavia and Rwanda that the conviction that criminal accountability was necessary for the restoration and maintenance of peace and security was explicitly expressed. Massive human rights violations, including when occurring within a state's borders, were considered threats to international peace and security, and individual accountability for such violations as a measure to restore and maintain them. Practice shows a steady trend within the international community to request the Security Council to refer situations of massive human rights violations through criminal mechanisms. Initially harshly criticized as not falling within the measures contemplated by Article 41 of the UN Charter, the creation of criminal justice mechanisms by the Security Council to address situations threatening international peace and security has been legitimized over the years and has received ultimate consecration in the International Criminal Court, the ICC statute. Indeed, the Security Council is among the trigger mechanisms of the court's machinery. This triggering power is restricted to an action taken under Chapter 7 of the Charter of the United Nations. This presupposes that the Council is of the view that a situation of massive human rights violations is constitutive of a threat or breach to the international peace and security. As noted above, numerous Security Council actions, particularly since the 1990s, confirm that the political body conceived massive violations of human rights, including those which threaten regional stability and those occurring within a state's borders, as sufficient to trigger Chapter 7 powers. Based on this power granted to it in the Rome Statute, the Security Council has thus far referred to situations of gross human rights abuses for investigation and prosecution to the prosecutor of the ICC, one from Sudan regarding the conflict in Darfur and another concerning Libya. Similarly to the International Criminal Tribunal for the former Yugoslavia, the ICTY, which operated for some time in the context of the raging conflict in the former Yugoslavia, the ICC's involvement in Sudan, Uganda, the Democratic Republic of Congo, the DRC, Côte d'Ivoire, Ivory Coast, and the Central African Republic and Kenya is taking place in the midst of ongoing armed conflicts or violent social tensions. Its potential preventive and deterrent effect, which cannot be measured with accuracy, accounts at the very least for growing awareness among warring stakeholders of the readiness of criminal liability mechanisms to investigate into their misconduct. The court's watchful eye, in Colombia for instance, can also act as a threat to actual and potential perpetrators of international crimes. Despite its potential capacity as a deterrent, it is acknowledged that justice initiatives may in certain circumstances need to yield temporarily to short-term peace objectives. Article 16 of the ICC statute, in recognition both of this potential necessity and the overarching role of the Security Council in that regard. The provision which allows deferral by resolution adopted under Chapter 7 is indeed premised on the rationale that prosecution, which can sometimes be considered a redress to a threat to peace and security, may at other times constitute a possible impediment to its restoration. To explicitly declare that justice is at odds, even temporarily so, with peace is a very delicate statement to make. It is hoped and expected that the Council will use its power with great circumspection and only in exceptional circumstances. It should be noted that one should be cautious about the excess of confidence in international criminal justice as an instrument of peace. Absent strong political sponsorship, namely the backing of an organ such as the Security Council. As M. Sharif Basuni rightly puts it, threats to peace and security are essentially political judgments. Even when the Council has found that criminal prosecutions are a desirable measure for the restoration of peace and security in a given situation, its lack of effective support with the enforcement of subsequent measures adopted within the criminal justice system seriously undermines the credibility of international legal order. Impunity through non-enforcement of international arrest warrants that have been backed with Chapter 7 authority cannot be permitted without fundamentally undermining the credibility of the notion of an international rule of law. This lack of consequent follow-up in the situation of Darfur gravely undermines the credibility both of the ICC and the Security Council and weakens the international legal order. In any event, to understand how international criminal justice has the potential to restore international peace, it is necessary to look at how it can contribute to the marginalization of those who bear the greatest responsibility for gross human rights abuses.